You're welcome to my channel. My name is Benjamin Amefle. I'm a Nigerian legal practitioner. In this channel, we discuss Nigerian law. Any topic in Nigerian law is what we discuss. Today we are going to discuss a topic under Nigerian matrimonial law. We're going to look at offenses that can be committed in the process of celebrating marriage under the Act. We have identified 10 of such offenses that can be committed in the process of celebrating marriage under the Act. And we're going to outline them straight away. Before we go on, I want to make a very humble application. Please do us a favor to subscribe, like, comment, and share this video. Share this video, and God will bless you. Share this video so that anytime we upload any video, you'll be the first person to see it and view it. Now let's go straight to the point. Offenses that can be committed in the process of celebrating marriage under the Act. The first offense there is marrying a person who is already married. In marriage under the Act, the only person that are expected to marry under the Act are singles. That means people that are not married, or even if you are married, the person is either divorced or the person is a widow. There is no subsisting marriage. So the persons to marry under the Marriage Act should not be people that are in a subsistent marriage. So if anybody marries another who is in a subsistent marriage, that person has committed an offense under Section 39 of the Marriage Act and liable to 5 years imprisonment. The second offense that can be committed in the process of celebrating marriage under the Act is making false declaration. There are certain statutory declarations that are expected to be made by certain persons, such as the marriage registrar or the ministers of a licensed place of worship or the parties to the marriage or even witnesses to the marriage. If there is any statement that is expected to be made by any of these persons or any declaration or any document, and there is a false statement in that document or statement, such person who makes that declaration, statement, or whatsoever has committed an offense and is liable to either 1 year imprisonment or 5 years imprisonment. The person will be 1 year imprisonment. The person will be liable to 1 year imprisonment if he made such false statement or declaration negligently. That means he did not know. He was not diligent to find out the truth. He will be liable to 1 year imprisonment. But if it found out that he knowingly made that, if it is found that he or she knowingly made such false statement, he or she will be liable to 5 years imprisonment. All right. The third offense that could be committed with respect to celebration of marriage under the Act is false pretense of lawful impediment. False pretense of lawful impediment. That is, when a person who is not a party to the marriage does not want the marriage to go on, he now make a false declaration or a false statement and make an allegation that will show that the parties to the marriage are not qualified to marry. For instance, alleging that any of the party is a minor. If this happens by some parents, if some parents do not want their child to get married with the person he or she wants to marry, they could make a case claiming that their child is only a minor, not up to 21, and therefore requires their consent, and they do not want to give that consent. For instance, a person who is 18 years or anybody who is 21, or anybody who is less than 21 years who wants to marry must need the consent of the parents. If the consent of the parents are not obtained, such marriage cannot be celebrated under the act. Now, if a parent knows of this lawful condition and your child wants now to go and marry a person you don't want him to marry, you can now leverage on this and now come and tell the even if the person is up to 21 years or up to 25 years, you now tell lie that the person is 17 years or 18 years, so that you'll be asked to give consent, and you now say you don't want that consent. If it is found out that you are telling lie in order to um, pretend that there is an impediment, such lie or such false declaration is an offense and punishable under Section 41 of the Marriage Act and liable to 2 years imprisonment. The fourth offense that could be committed with respect to celebration of marriage under the Act is unlawful performance of the wedding. Certain weddings are unlawfully being performed. This happens in a situation whereby the minister or the officiating minister or the it mostly happens with respect to officiating ministers of some places of worship. If a minister that celebrates the marriage is not from a licensed denomination that is licensed to celebrate marriage, that marriage is invalid, and such minister who celebrates that marriage is liable to 5 years imprisonment. If the minister is not from a licensed place of worship where the minister of interior has licensed him to celebrate the marriage, and he goes ahead and celebrates the marriage without being qualified, it's an offense. Secondly, even if he is qualified to celebrate the marriage, he must ensure that there is no lawful impediment against the celebration of marriage. For instance, he must ascertain that there is a certificate from the marriage registry. If there is existence of any lawful impediment and he overlooks them and goes ahead to celebrate that marriage, both the minister, both the parties to the marriage, and those who witness the marriage have all committed an offense, and all of them each of them is liable to 5 years imprisonment. That is the provision of Section 42 of the Marriage Act. Now, the offense number 5 that can be committed in the process of celebrating marriage under the Act is willful neglect of performing a duty imposed by law. There are duties that the law imposed on the officiating ministers or the registrar of marriages, especially the officiating ministers. The law provides that they should, after the marriage, there is a form that ministers of a church that have been licensed to celebrate marriage, they always have a form. They have to fill that form. It's called Form E, as indicated in Section 24 of the Marriage Act. If they fail to fill those forms and return it in 7 days, they are expected to fill the forms and return it in a counterfeit of it, that is a duplicate of it, in 7 days to the marriage registry. If they fail to do that, they have committed an offense, and they are liable to 2 years imprisonment. That is the provision of Section 43 of the Marriage Act. Now, let's look at the sixth offense that can be committed with respect to celebration of marriage under the Act. That is personation in marriage. The law says under Section 44 of the Marriage Act, and I state it like this: say, whoever personates any other person in marriage or marries under a false name to the registrar of marriages willfully fails to perform such duty shall be liable to imprisonment for 5 years. Whoever personates any other person in marriage, or marries under a false name to the registrar of marriage, or the registrar of marriage willfully fails to perform such duty. Now, if the registrar of marriage is presented with a name that is a false name, and he now celebrates the marriage, the person that presents that wrong name has committed an offense and is liable to 5 years imprisonment. We also have fictitious marriage. That is the seventh offense under the Marriage Act. Anybody that commits a fictitious marriage, the law provides as follows: whoever goes through the ceremony of marriage, or any ceremony which he or she represents to be a ceremony of marriage, knowing that the marriage is void on any ground and that the other person believes it to be valid, shall be liable to imprisonment for 5 years. Fictitious marriage is a situation whereby you deceive the other party that there is a marriage, whereas you know that there is no marriage. You celebrate the marriage knowing that it's a false marriage, with the purpose of deceiving the other person that there is a marriage. You initially know that there is no marriage, that you know what the law provides, and you now celebrated it in a way that it is void, so that tomorrow, when they now hold you responsible as a married man, you say, you now cite what the law says. If you celebrate such marriage, fictitious marriage, knowing that nothing exists, an empty marriage, you'll be liable to 5 years imprisonment. That is the provision of Section 45 of the Marriage Act. Now, we are going to look at offense number 8 that could be committed with respect to celebration of marriage under the Act. That is contracting marriage under the Act when already married under native law. A person should not marry when there is already a pendency of marriage under the native law. For instance, you have already married under the native law. You now leave that marriage and come back to marry another person under the Act. It is an offense and punishable with 5 years imprisonment. Now let's look at the 9th offense that can be committed under the Marriage Act. That is contracting marriage by native law when already married under the Act. That is vice versa. If you are now, after you have married under the Act, you now go ahead to marry under the native law and custom with another person, or even with the same person, it is an offense, and such offense can attract 5 years imprisonment. Section 46 of the Marriage Act. Okay, the last but not the least is marrying minor without prescribed consent. Somebody is a minor, and you find out, you know that he's a minor, and there is no consent of the parents or the person that is acting in locus parentis, that is acting the place of his parents, and you go ahead and marry that person. Marrying a minor is an offense, and such person has committed an offense and liable to 2 years imprisonment. A minor, within the meaning of the Marriage Act, is a person that is below 21 years. Anybody that is below 21 years does not have the right to make a marital decision under the law. He can, if he's below 21 years, although we have a Child Right Act that have made it 18 years. For there to be agreement, a person that is 18 years may marry, but provided he is not up to 21 years, such marriage will be with the consent of the parents. So an 18-year-old person who intends to marry under the Act is allowed to marry to satisfy the requirement of the Child Right Act. But he needs the consent of his parents or anybody acting in locus parentis. So if his spouse or the other partner marries him or her without that consent, it is an offense under our law. It's criminalized under our law, and such a person will be liable to 2 years imprisonment. Thank you very much for listening to us. As I said before, do not hesitate to subscribe, like, comment, and give us thumbs up. Subscribe so that anytime we upload video, you'll be the very first person to see it. Thank you, and thank you once more. Remember, comment and ask us any question you want to ask us, either on this topic or on any topic bordering on Nigerian law. Thank you, and thank you very much.